morning, everyone. Welcome to the First District Court of Appeals. We have 3 cases up for argument today. I will go through the cases, and if the attorneys would please enter your appearances and indicate your readiness to proceed. The first case we have is C-22-0481, In Re E.M. For appellant.
Your Honor, Monica Welker for Mother Robin Mage.
Thank you.
May it please support Alex Vanderzee for Father Lee Collier.
Thank you. The next case up is C-22-0357. It's Watering v. CBT M. Elberon.
Your Honor, Paul Crouchshore for appellant battery.
Good morning.
May it please the court, Your Honors, James Patrick Kirk on behalf of the appellate CBT and Elberon LLC. We're ready to proceed.
Good morning. And the final case up for argument today is C-22-0624, State of Ohio versus Nicole Jones.
Good morning, Your Honor. Chris Badisky and Spencer Hatterman for Ms. Jones. Mr. Hatterman will participate, and we're ready to proceed.
Good morning.
Good morning, Your Honor. Keith Sauer for the state. I'm ready to proceed.
All right, good morning. Okay, In Re E.M. Ms. Welker, would you like to reserve some time for rebuttal?
Yes, Your Honor. 3 minutes?
3 minutes? Okay, and then I'll be using the lights at the podium, so when you have about 1 minute of your first initial time, the yellow light will come on and the red light means you've used your time, okay?
May it please the court, Monica Welker on behalf of the appellant, Robin Mage. Your Honors, this is essentially about the length of time it took the trial court, Hamilton Juvenile, to decide a case regarding a toddler. This case took 4 years to get from initial filing to determining of an objection. The objection actually only took about 9 months. The vast majority of that case was at the trial level. One of the many causes of the length of time was COVID, but we also should not allow COVID to affect the life of the child.
And I've been concerned about some of the delays, particularly in parental termination cases. But I read your brief and I don't see any authority for the proposition that you're arguing. So what is your best authority to say this is an error that warrants reversal?
Understood, Your Honor. I think the best authority is the best interest of the child itself, found in 310904. It's not in the child's best interest to have decisions made for it that are 4 years old when the child is aged 4 years. Civil cases are not like criminal cases, as you know, of course, where there's a definite right to have your case heard within a certain amount of time. And obviously, juvenile court, due to the sensitive nature of its work, has sort of its own, it's given lots of leeway when it comes to some of the decisions they have to make because they have to do what's best for the child. However, in this case, the length of time it took was definitely unjust. I don't believe there's a strong source in favor of a time limit because of the sensitive nature of cases. However, in this case, it obviously took too long.
Well, how much, so you said that 9 months of the 4 years was litigating the objections, right? Is that what you just said?
Yes, there were several continuances, several needs to push things back, et cetera.
Okay, so what amount of time was just due to the COVID delay out of those 4 years? Because there were continuances by your client requested, correct?
Yes, Your Honor.
Okay.
The case was, the main effect of COVID on the case was from March to June or July of 2020. That was when the courts weren't open as much. That was when, basically, unless it was an emergency in Hamilton County, it was hard to get in front of a magistrate or a judge.
So March 2020 to July 2020?
I would say yes.
The COVID delay?
Yes.
Okay.
After that time, the courts were hearing cases, just everyone had to be masked up, behind glass, et cetera, et cetera. Okay. So the fact that the most important thing I think when we talk about the delay is the staleness of the evidence in this case. the GAL in this case looked at a toddler. And by the time this case was done, this child was school-aged.
So your issue's not as much the delay as the fact that the delay caused the evidence to be stale.
Correct, Your Honor. I think we have to appreciate, sometimes cases will take a long time, but as long as the court's looking at the child as it is, as close to the day of the decision as it can, as opposed to the day of filing, and because of the nature of children, I think the court has to do that. Unlike other cases where it goes by what things, the status quo is the day of filing. When it comes to children, that's why we appoint guardians ad litem, was so that they can keep abreast of the child's needs and the child's wants. In this case, there was a long period of time, and as far as we can tell, there was actually only one visit by the guardian ad litem to the child and had been years prior.
Did mother ask for the guardian ad litem to do a second visit?
Yes, but I do not believe we have written documentation of that. I think it may have been oral.
Is it on the record?
No, it would have been private channels.
Okay. I mean, that could have been done, right? A request saying, look, Judge, we've had this COVID delay, the evidence is stale, we would request another evaluation, another visit so that we can get more up-to-date evidence before we start proceedings.
Yes, Your Honor, that could have happened. I wasn't the trial attorney, so I can't explain exactly what happened there, except to say that Mom definitely wanted that to happen. It did not happen.
Well, what are there, in related vein, were there any objections to the delay that mother raised at any point? Did she jump up and down and say, look, this is taking too long, I want my hearing now?
I believe mother's objection covered, was one of the many things mother's objection was about, I believe, was time.
No, I mean during the proceedings. I'm not talking about the objection to the magistrate's ruling, but like during the course of this nearly 4 years, at any point in time, did mother kind of tell the court, this is taking too long, this is ridiculous, we need this heard now?
On the record, you'll find it in the appellant's trial attorney's questioning of the GAL. She discusses how long it had been since she's seen them. I think it's the closest she'll get. You know, the mother did not file any formal objections with the court except for her final objection to the magistrate's decision.
Well, I think that's the problem in these cases out of juvenile court, because a lot of times what happens, at least from what I see on the transcripts, is you've got multiple parties often, you've got GAL involved, and then they all sit around and say, well, I can't do it on this date, I can't do it on this date, and then the next thing you know, the next hearing is like 6 months out. Well, from my perspective, that looks ridiculously long, but those are the lawyers making those determinations and no one's objecting to it. So, I mean, that kind of puts us in a bind when you come to us and say, like, it's taking too long.
I understand, Your Honor. I think if we were doing, if they had done a two-front thing, which is kind of what we did in our appellate brief, it's taking too long and the evidence is stale. If we know things are going to take too long, so long, then it's up to the parties involved, especially in this case the GAL, to update their information, make sure they're correct. I mean, for example, breastfeeding was discussed in the decision. The child had been breastfed at this point for quite some time.
It was discussed, but was it really what the court relied on in making its decision?
The court's decision focused on the attachment between mother and child. They felt it was, for lack of a better term, unhealthy. And that was one of the two things they pointed to, three things they pointed to. They pointed to breastfeeding, they pointed to co-sleeping, and they pointed to the reaction the GAL saw one time when the child was at a transfer between the parents and did not react well. And appeared to be afraid, and mom had to carry the child to the car.
I'm looking at the court's best interest analysis, and it doesn't seem to focus on the co-sleeping and or the breastfeeding, but more the distrust your client has for the father. In addition, there have been several allegations, unsubstantiated allegations of sexual abuse, and it notes that the mother now admits that that did not occur. I think there were 3 instances of that. And can you address that, ma'am?
Sure, Your Honor. In this case, obviously, the parties are no longer together, so obviously there's going to be some distrust. Allegations are not uncommon in these kind of cases, Because of the length of the case, however, it's hard to say if one party felt that way at one point, and then down the road, they may have changed their mind. Mother was asked during the trial
Well,
about
those
that.
those are fairly serious allegations.
I'm sorry, Your Honor.
Those are fairly serious. Those are criminal allegations. They're fairly serious. And I
Yes,
think
they-
the court.
yes, they are, Your Honor.
And so it seems like the court looked at that as well.
Yeah, absolutely, Your Honor. Those are serious allegations, and if a mother or father truly believes those allegations, they have to speak up about them, and they have to have them investigated. My understanding is these were investigated, and there was no hard evidence provided of it. However, because Mom raised these questions at one point, it shouldn't be held against her, because, she wasn't making these up whole cloth. She had concerns. And when a parent has concerns about these things, we would condemn them if they didn't bring them up and investigate them as they could. So we would hope the court would at least give this case, for lack of a better term, a do-over, a chance to have this case relooked at again with fresh evidence, and to see that where the parties are at the time of the decision as opposed to where the parties are the day of filing. Okay, thank you.
Thank you. Whenever you're ready.
Good morning, Your Honors. May it please the court, Alex Vanderzee for Father Lee Colliver. And admittedly, this is my first time in front of you, so I'm a little nervous. I'll be addressing some of what Mother's Counsel had brought up. First of all, the time issue. The time had never been an issue until very recently. Importantly, it has, as you all had already discussed with counsel, it had never been objected to. Mother actually requested 2 of those continuances, and Father never requested any. I've been his attorney since 2018, and he had wanted this done as speedily as possible, most efficiently as possible, and the right way, of course. But he never wanted to have any kind of continuances. So I just find it...
So Father never requested any continuances in
Not
this
that
case?
I can recall, and not that I have seen in my review of any record.
Well, and so back to my question to opposing counsel, like, did anyone object to the length of time this was taking, as best you
Not
understand?
officially on the record. I mean, of course, my client was frustrated with how long it was taking, but never
I
anything.
mean, no one's objecting to the court and saying this is taking time.
No, Your Honor, no. I think it was understood because so much of this happened during COVID, and it was a world that none of us had lived in. The magistrate herself at the beginning, it was Magistrate Kelly, who was saying, our docket is too filled up, or whatever her reasons were, and we did not formally object to anything. And I think notably, Mother didn't either, because she really had the advantage while all of this was pending. She had the time schedule she wanted. She had the child in her home. She was able to conduct her life the way she wanted to. So I don't believe that the time factor is actually a genuine concern for Mother.
So what is someone supposed to do that is in this situation and it's taking, way too long? Like, what are their realistic options for relief?
I think that's an excellent question, and I don't think I have a good answer for that. I only practice family law, and I'm in 800 Broadway pretty much every day of my life, and I'm one of those attorneys when you say no to the day, no to the calendar, and I'm sure you see all that in all your transcripts because there's just not enough time on the docket, and we're all very busy, and we can tell our clients, if you'd like somebody who's less busy or if you want a different court, go move somewhere else for 6 months and try there, but it's not realistic in our court the way that it is set up right now.
And the court docket backlog, I mean, it takes a long time to get on the calendar anyway. And then to be
Absolutely.
able to coordinate everybody's schedules seems very difficult.
Yes, and our court was backed up before COVID, and then that certainly made it, worse. My client was ready to proceed at trial every day we were there. Notably, there were several allegations that were eventually unsubstantiated sex abuse allegations. This was a huge theme of this case. Mom, I don't know if they were genuine or fabricated, but she made several allegations, many allegations of sex abuse by my client against the child. All of them were unsubstantiated, and all of them could have potentially caused harm between my client and her child. It wasn't just one, and notably, she made an allegation to Mayerson after this court even told her not to. The trial court specifically said, you'll make no more allegations of sex abuse, and she did anyway. I think that is important for this court to note. There was much made about breastfeeding and co-sleeping, and as I think the court already asked some questions to opposing counsel about this, it really wasn't a substantial issue. It wasn't that this mom had decided to breastfeed longer than usual or co-sleep with her child. That wasn't the issue. It was that she was using it to then say, the child can't go spend the night at dad's house or is too afraid to be away from me, and it wasn't genuine. That's always been my client's thought of that.
But at the same time, the argument is that by the time this case was tried, she was no longer breastfeeding. She was no longer co-sleeping. So even relying on, what you just said seems to be relying on stale evidence.
I don't believe that evidence is stale. Especially in juvenile court, kids are growing every day. And the guardian ad litem and the court has to look at the evidence that's presented to it at that time. And at that time, that was something that had
Right,
been
but this
recent.
gets back into the delay question and the issue that I've struggled with before in these type of cases where because, the hearing might take place over an 8-month period, by the time the last testimony is taken, it's still on a look back to the beginning of the case unless there's been some new investigation. And then that kid has, as you said, evolved over that period of time. But how are we supposed to reconcile that?
Well, I think it's important to also note that our guardian ad litem had been there the whole time. So counsel notes that the GAL had been to one visit, but that didn't mean she stopped her investigation. She had continued to be in contact with mom and dad and counsel, come to court proceedings, and knew the trajectory and the counseling and the schooling and everything that was going on with this child, and still believed it was in this child's best interest to be with her father.
But I'm trying to understand, you said that mother was using the breastfeeding and the co-sleeping as an excuse to not allow the child, to say that the child couldn't visit with dad? Is that what you said?
That was partially it, yes.
But then she stopped breastfeeding and she stopped co-sleeping. So that was not an excuse that she had at the time of the trial. So how is that even relevant, the breastfeeding and the co-sleeping, to the visitation with dad?
I think it's something that's notable, but not something that was heavily weighed in the ultimate determination here.
So what was heavily weighed in the ultimate determination here?
I think quite heavily was the consistent allegations that were unsubstantiated of sex abuse.
And before the hearing, when was the last allegation? How much earlier was the last allegation of sex abuse? I'm just trying to understand.
And I'm trying to remember, yeah.
Yeah, because she said she stopped believing that as well and stopped doing that.
She did say that, yes.
And I'm just kind of curious as how long of a gap we had.
I don't think, to an official police officer or Mayerson or JFS, I don't know exactly how long, but Mother maintained the day we walked into our last hearing that there was sex abuse going on. It wasn't until I feel that the evidence was so heavy that there was nothing going on that she changed her story because it was really starting to seem outlandish. And I think that was the first time that she really thought, okay, no one believes me. I'm going to change my story.
But that was the major thing that the court, in your opinion, relied on in deciding this custody dispute was what the court, I guess, believed were they were unsubstantiated allegations of sex abuse.
And how often they were occurring and how serious they were. These, not to put sexual abuse on a scale, but this was tantamount to raping this child, oral sex being performed on this child by her father, which didn't happen. And that's a huge factor, I believe, that the trial court took into consideration. Thank you. Thank you.
Is that all you have? All right, thank you. Ms. Walker, you actually only used up 9 minutes, so you have 6 minutes if you
All right,
want.
I won't subject the honors to 9 minutes of me talking. All right, if you may please the court. To answer the question Your Honor just asked, it was 2019. That was the last time mother made any allegations. And what happened was she had spoken to authorities in Kentucky because she was there then. They opened an investigation. The cabinet in Kentucky opened an investigation, and they recommended to her, not knowing what Hamilton County had said, that she do that, and she did that. And then the court ordered mother to undergo psychological evaluation, which she did. The only thing the psychological evaluation found was that mother had distrust of father. There wasn't any overwhelming psychosis or anything odd about it at all. So just like with the minor arguments of breastfeeding and co-sleeping, mother's accusations against father were also stale at that point. Mother was not at that point making strong accusations against father. She hadn't taken the child anywhere to be investigated since 2019.
What was the date of the hearing then?
I believe the final hearing
Yeah.
was April 2nd, 2021.
And that's when mother said that she no longer believed that father was abusing her child?
Yes, I think it's, my notes say it was on page 8, line 16 of the April 2nd, 2021 of transcript.
Okay.
So, again, because the court at some point disliked, and for good reason, maybe perhaps, mother's accusations without hard evidence, the court seemed to dismiss everything she said. So therefore, when mother said, at 2021, I don't think this is an issue anymore, and the court heard that, the court didn't take into consideration, I think, because the court was relying on the stale evidence that heard from the GAL. I don't want to appear to be blaming the GAL for everything. With COVID going on and people restricting their homes, everything, I'm sure it was complicated. But I think the GAL, knowing that she had a duty to respond, to investigate, I apologize, and to investigate, definitely she should have at some point asked the court to do a further investigation. Obviously, either parent could have as well, but in this case, because the GAL is the one who signs the report and the one who testifies about her report in court, she should have made sure all her evidence and all her observations were still relevant and up to date.
So you're saying that the GAL didn't have any further because I thought appellate's counsel just said the GAL maintained contact with both sides.
The GAL made, to the best of my knowledge, Your Honor, the GAL made no visits to the house prior to the very first hearing on this case, very first trial date of this case, which was in 2019.
Visits to the house, but what about further contact in some way, such as phone calls or?
I can't speak to that, Your Honor.
Okay.
To go back to the length of time, counsel was talking about how we all know, we all get our schedules out and set them. However, there are magistrates and judges who will say, this has to be done by this date. You need to find time or get someone else to cover this for you. I've had that. Everyone's had that happen to them at some point. There are, Rule 40, I believe, it's Rule 40, has some guidance for cases. Once you get to the 180-day mark, the court does, Rule 40 does want the administrative judge to take a look into things. And there's no evidence whatsoever, of course I wouldn't have access to it, of the administrative judge ever taking a look at this case and saying, whoa, this has gone on too long. If you look at when COVID essentially lifted in July, the case wasn't set until November. 4 months later, in those 4 months, nothing could happen in the case legally. And it's confusing as to why that could happen when the court, knowing that COVID had a lot of cases sitting, the court didn't do something that permitted it to hurry up and get caught up, whether it be Saturdays. There's lots of things the courts could have done that didn't do for the best interest of the child. In this case, it affected the child negatively by changing the child.
I think part of the issue with your argument, though, is you're putting the burden on the court when no one is saying, we need this decided right now. Like, none of the parties are telling the court, this delay is too long, don't keep it going. Like, there's urgency here. So, like, I feel like that's part of the disconnect here is if the party is being disadvantaged by the delay, it's incumbent upon the party to raise that to the court in some fashion.
I understand what you're saying, Your Honor. If you look at the transcript, mother herself, in her answers, states that she's not breastfeeding anymore, she doesn't believe father committed sexual aggressions against the child anymore, and she's no longer co-sleeping. And the child is no longer resisting going to the car and walking to the car. She's now able to walk to the car herself, to father's car. So mother, in her knowledge, was relying on her testimony to be believed by the court and to be understood that the things that the other side was presenting were no longer true. Again, unfortunately, the court chose to go with the stale evidence as opposed to relying on mother's testimony as to what the case was that day. All right. Thank you, Your Honors.
Thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision.
Thank you.
Have a good rest of your morning. Next case up is Watering versus CBTM Elberon. Good morning.
May it please the court, I'm Paul Kraushaw, representing
Wait,
Mr.
hold
Mitchell.
on 1 second. We need to switch out counsel. That's all right.
A little too eager.
Yeah. Okay. And would you like to reserve some time?
I would like to reserve 3 minutes, Your Honor.
3 minutes, okay.
Your Honor, this case presents a situation in which really all three areas of policy, the rules and the facts all sort of mandate a reversal. What we have here is a valid judgment, not a default, taken after service and an answer by the defendant that's been with a final judgment taken after an evidentiary hearing that's been on the books for 2 years, certificate of judgments filed, foreclosures filed. They answer the foreclosure case, which is a companion case. 4 months later, they move to vacate. The trial court seems to maybe think that this is a COVID situation, but COVID, at the time these events happened in our case, COVID was still several months in the future. No one had heard of Chinese virus or anything like that at the time. And then without having an evidentiary hearing, the court vacates the judgment.
What significance should we ascribe to the fact that it was the same judge who granted the judgment and had the evidentiary hearing that then essentially walks it back by granting the relief from judgment?
It might have some relevance, Your Honor, except that the judge does say that this is a COVID case. If he thinks that it's a COVID case, I think that ameliorates any memory of his about what this case involves. He's demonstrated that he doesn't really recall.
Well, the
this
parties didn't remind him or correct him that it was not a COVID case?
Well, Your Honor, there was no evidentiary hearing. There was simply a hearing on the record where CBTM's lawyer says we would move to vacate. Mr. Watering's counsel says he opposes, but they never really get into any of the facts. The judge says, this is a COVID case, I vacate.
So you're saying that there was no opportunity for Mr. Watering's counsel to tell the judge, well, Judge, this is actually not a COVID case?
If there was, he didn't exercise. It's hard to tell from the transcript, as always.
He didn't do it.
He didn't do it.
Okay.
Well, but I guess I'm confused because it looks like the judgment was entered in February of 2020, so right on the cusp of COVID. And maybe that's what the judge was meaning in terms of that's part of what is justifying the delay here.
Well, it's not, see, it's not doing it, I don't get the feeling that the judge is saying it's a justification for the delay. He's saying that it's a justification for them not appearing in his court to defend. I mean, we have withdrawal of trial counsel, 5, I think, continuances, and then an evidentiary hearing at which Mr. Watering testifies. And that's when the entry comes out in February. But all of those prior events are long before COVID, because COVID, I was on my anniversary trip driving through Tennessee at the time of COVID, and they're talking about shutting down the border between Kentucky, all the Kentucky borders, and saying we couldn't get home, so we turned around and we came back home. This is in March. The fact that it's well after that final hearing, and they've missed deadline after deadline after deadline.
But that wasn't the justification that they used. They didn't use COVID.
They used 60B1. They said we have a meritorious defense.
'Cause they didn't know about, I guess, they didn't get notice, is what they were saying.
Here's the problem. They used that address in civil litigation in Hamilton County Municipal Court, that 159, P.O. Box 159. They used that address in a littering ticket where they had the hearing a month before Mr. No's withdrawal became effective. They clearly are using the Ohio courts in that period. They had notice, they answered, they appeared, they're suing people with that address.
Well, but was, after the withdrawal was granted, is there evidence in the record that notices were then sent to that address?
There is a statement in the docket that notices went out. But of course, the clerk doesn't say where they sent notices, but that's the notice they have, that's the address that the clerk has for CBTM, was the P.O. Box 159.
Okay.
So that went out, but then there's
The references you just made to other proceedings, was any of that filed in this case in the record here?
it was not, Your Honor, because there was never an evidentiary hearing. So it's, I guess the court can always take judicial notice of other cases. I have the case numbers if you'd like, but it's really, it never was presented to Judge Ruhlman because there was never an opportunity. So there was no discussion.
Well, you had an opportunity to oppose the motion, right?
Yes, they filed a motion to vacate. Mr. Watering's then counsel opposed, but I think he just opposed, saying that it's too late to do a 60B1. And so we have other cases before the court where 60Bs are attempted even shortly after the default judgment is granted, and they say, well, you haven't met the standard. You don't have a meritorious defense. When a ceiling collapses on a tenant and they have personal injury damages, $122,000 in actual damages and permanent disability, and Mr. Watering is disabled to this day, you don't need negligence. It's you're kind of a res ipsa, and the complaint was not only for negligence but for failing to maintain the premises.
Right, but they then tendered evidence that says that's ridiculous. He's not really injured. He was totally fine.
They presented it over 2 years later, Your Honor. That's the problem.
So your real argument is this is a 60B1 situation?
Yes, ma'am. This is a 60B.
And if they had filed within the year under 60B1, then you think they probably would have made their case?
I don't think so. Actually, the evidence, I think, would have come out very strongly against. Their evidence is that the handyman that they have an employee in Ohio said he saw that the building had collapsed. He didn't notice anything about Mr. Watering's injuries, and Mr. Watering didn't say anything. Mr. Watering would deny that. He would say...
Yeah, but do we get into all that on meritorious defense? I mean, they just had to present some sort of defense, right?
If they had done within the year, I think they would have been...
That was my question.
And there was a hearing.
Right.
And we could have teed this up and actually...
Yeah, I'm not saying they definitely would have won. I have no idea. I'm just
Right.
saying that they came up with a meritorious defense in this case, right?
They have alleged one.
Okay.
I think it would... I believe...
Your argument is that 60B5 is not the appropriate
Right, there's
section.
just that sliver of situations where 60B5 is useful. There's a case involving bigamy where the bigamist sent the notice to one of his wives or he did by publication, even though he knew that where she was living at a former residence that they had shared. That
I remember that case.
there's just this little tiny sliver of B5 where it's appropriate. Everywhere else, it should be B1 through 3.
Well, let me ask you, Mr. Croshaw, this is, it's $1 million judgment. I read the transcript, the hearing where your client was sworn and testified, but it consisted of 10 pages. And the judge at the end said, well, how much do you want? And the attorney said $1 million. He said, okay. I don't know why he didn't say $5 million. I mean, do you understand what I'm saying?
Yes, sir.
In my mind, it seems to me that the court still retains some equitable powers to fix a mistake or fix an error that it may have made previously under the rules. The Court of Common Pleas has certain equitable powers. Mm-hmm. And in my mind, that's maybe what the judge did here, because I've been a judge for 25 years and I've presided over numerous trials. I've never seen $1 million verdict.
Your Honor, if it had been $5 million on 122,000
I would have asked for, why didn't $10
actuals,
million? You should have asked for.
right?
I know it wasn't you, but that's what,
Right. If
the
it had-
gist of it is the judge just said, okay, $1 million.
$1 million, but $1 million on 122,000 is not an outrageous amount if it's on a
Well,
permanent
if
injury.
they bring up Robinson Bates, and they also bring up, somebody else may have paid for those, whatever, $122,000. I mean, that's not really before us, but all I'm saying is 5 questions, and all of a sudden you get $1 million judgment, which is great. That's good for you.
Well, but see, now since it's vacated, my suspicion is that on the back end, if this court reinstates the judgment, they're going to find that the property may not be collectible. I've done a fair amount on both sides that it's.
May have been sold.
It may be
Speculating.
moot.
Okay, I understand.
So there's, how do we predict that future? Where do we end up? But I don't think it's outrageous for $1 million. Kim Adelstein, my former client up in federal court, just won $1.1 million for discrimination case against the judge up in Butler County for terminating her as the magistrate.
That was after a trial, a full
Yeah,
trial.
right. Oh, yes. Well, this was after evidentiary hearing. And I agree, Your Honor, it was a very short evidentiary hearing, but it was based upon the actual injury and the permanency of the damages.
Okay.
So, if the court has any further questions, I will reserve.
All right, thank you.
Thank you.
May it please the court. If I may, it's absolutely within the sound discretion of the trial court judge to review their own judgment, the proceedings that are underpinning of that, and then after faced with unrebutted evidence that's in the record in the form of affidavits to say, hey, it's a mistake. It's unjust.
But they can only do that if this fits within the narrow confines of 60B5 because of the timeliness.
Well, Your Honor, absolutely, but 60B5 is the inherent power provision that says it's.
I know, but we've also had many cases that have said this isn't this broad, nebulous thing that swallows all of the specific rules, because otherwise no one would bother with the specific rules.
Sure, I would acknowledge that it's confined to what extraordinary or unusual circumstances, and I think here the case is unusual circumstances. There are 4 lapses of notice that occur that lead to all of this.
But I guess here's the thing I'm struggling with in this case. The attorney was retained by your client. So someone picked up the phone and called this guy and says, will you represent us in this case? And he said yes. He files the answer and starts to litigate, and then suddenly he can't reach anyone. And he sends notices to them, but doesn't apparently call anyone, which just I don't understand from an ethical standpoint. And then, like, we have this second affidavit of your client who says, yeah, I knew about the lawsuit. I just kind of assumed everything was taken care of. So that, to me, sounds like excusable neglect.
Your Honor, the reason it's not is they don't know. What happens is the lawyer, for unknown reasons, they file, I believe, an answer in March, and he moves in May, 2 months to to be relieved from his duties, withdraw. And the information that he's sending is not getting to the client. My client says in the second affidavit that there's a property manager, former property manager, who was using that address, apparently. And so that's where it appears. Now, there's nothing in the record that says even notices were going there, but assuming that that's the address that is constantly repeated, it's not an address of CBTM Elberon. And it's this former property manager, perhaps, but nothing indicates that notice was ever given. Starting with notice that they're withdrawing as counsel. They don't even know. They don't show up.
I mean, but if we agree with that, though, I mean, clearly your client knew about the lawsuit, right? I mean, they answered.
They did, Your Honor, with the exception that, and it's in the affidavits, they found out in a very indirect, unusual way. They're looking at accounting, and they see a line item for an attorney, and they're like, what's that all about? So they don't even know the lawsuit per se is the lawsuit. They know a lawyer has been engaged somehow, some way.
Then they have the duty to look into it further and see what's going on. Somebody's got to monitor it.
They were told that there was an attorney involved at the time, but that attorney subsequently withdraws unbeknownst to them. They don't know.
Right, but then there's silence and they don't do anything about it.
Well, Your Honor, they are assuming, and there are cases, that kind of follow the same line, which is, whose duty is it? I mean, they were represented. They had every reason to believe representation was being provided. They have no reason to believe representation is no longer being provided.
The cases that you're talking about, are they B5 cases or B1 cases?
Well, I've seen both, and the idea is that they have every reason to believe, until they're told otherwise, that they aren't represented. And they never get notice of that. And then it compounds itself.
But going to Judge Bergeron's point, it seems more like excusable neglect, right?
Well, the excusable neglect presupposes there's something that you're neglecting. They don't know. They have no, that's the whole notice.
But I think you're talking about, when you say they, you're talking about this person who's in California. But they, as the company, would include this property manager, whoever that is. He is an agent of the corporation, right?
Well, there's a statutory agent.
No, I understand that, but I mean an agent as in an employee or someone authorized to do business on behalf.
Correct, and what the affidavit says is it's a former property manager. It gets channeled to the wrong person. This person does not have the authority to act on behalf.
How do we know that?
Well,
he retained this lawyer, I guess.
Exactly, and that's what really.
I mean, she doesn't say in the affidavit like he had no authorization to do that. I can't believe it. I fired him as soon as I heard that.
Well, no, it said it was a former, and that they've now, after the fact, 2 years later, find out mail is getting channeled over there. Notices apparently they don't know anything about this suit, other than the fact that she sees that the first instance is suit because I see a line item that an attorney is getting paid. Beyond that.
So when did she see the line item?
I don't recall what her affidavit says.
Was it beyond the 2 year or beyond the 1 year deadline? When she noticed the line item?
I don't believe.
She says it was January. Sometime after the January 29th, on the date the complaint was filed, I discovered the line item.
So was that within the 1 year?
Well, Your Honor, again, we're not arguing excusable neglect because we don't believe you can neglect something that you don't know about. And I understand what the court's point is like, well, she knew something, that she had some modicum of an idea.
There was a lawsuit.
Well, but beyond that, she thinks it's being actively litigated by a lawyer.
She's assuming.
Correct.
Right.
And all along, and then she even says in her affidavit, we didn't hear anything, so we assumed it was dismissed. and there's nothing in that would put her on notice. Lawyer is gone. Hearings are being scheduled. Nothing. There's a statutory agent. They could clearly rechannel and get the statutory agent involved
But let me ask you this. So we don't know exactly when the property manager was relieved of his obligations, but if she knows that the property manager is interfacing with the lawyer. Now property manager is gone. Does she not then say, hey, I better figure out who's making sure this lawyer is representing my interest?
Yeah, I don't know the timing other than to say, Your Honor, that the belief was a lawyer was involved and that they were going to, that lawyer's taking care of things. They don't get notice otherwise. And frankly, I mean, that's why motions, Your Honor, has been trial court judges. That's why they bring in people and they say, hey, your attorney's withdrawing, and they take extra steps to ensure that they are aware that there's no lawyer involved. That didn't happen here. The instruction was go get a certified, or actually send it by certified mail, but it goes to the wrong place, apparently. We don't even have a record of where it went, other than to say it went to the wrong place. So the motion to withdraw, they don't get. They don't get the actual withdrawal itself. And so they have every reason to believe. And that's why, I mean, that's why the standard, it's an abuse of discretion. The judge saw that. And it's not a COVID. He does not say, I'm doing this because of COVID. It's a passing reference. Well, there's some craziness going on with COVID. What he does say is consistent with the equitable inherent powers that he has, which is people should get their day in court. In this one, they needed their day in court. And I'm going to give them their day in court. That's all we're asking.
This was a mess up, basically.
Yeah, I mean, it was a, I don't, it's not a comedy of errors, but it's one of those collective things that once it started, it never corrected itself.
And we don't have anything on the record when the lawyer withdrew and the judge said, okay, you can withdraw. Do we have your client's latest address here? Or, I mean, none of that was.
I'm sorry, Your Honor.
I mean, I'm just trying to understand, because normally that's what you do, right? When the client's basically, I mean, corporations can't go pro se, but you make sure that you have the correct and latest address so that the court notices can then go to the defendant.
There was no discussion about, hey, tell me, can you track down the right address? I think it was somebody should notify the client. That's me paraphrasing, but the general idea was somebody needs to inform the client. And the client was never informed. They're telling you they never got actual or constructive notice of any of that.
So whose responsibility is that? Is that the court's responsibility to ensure that they have the correct address, or is the lawyer that's withdrawing?
I believe for an unrepresented party. I mean, I think the lawyer owes the duty at the instruction of the court to proceed in notifying the client.
Which didn't happen.
Which we do not believe happened, but neither did the court or the clerk do anything differently. So it perpetuated that one fallacy that just continued, and nobody, my client certainly was not in the position to be able to correct it. They didn't know what was going on. Mm-hmm. And then you get into the kind of the equities, as Your Honor has pointed out. It's $1 million judgment, and really, if you read that transcript, what the judge said is, well, you showed up, what do you want? And they said $1 million. Granted, done. And that's not and I think the judge realizes that. I think it was just this very short, no, they didn't touch on any of the elements of negligence at all. They treated it like it was a default, even though it wasn't really a default. He even said, in one prior hearing, he says it's going to proceed as though it's a default because they're not showing up. Well, they're not showing up because they don't have notice. And, that is specifically what the rule is designed to prevent. 60B-5 is exactly that. It's to say, don't let unjust situations happen. And we know it, and it's unrebutted. Counsel indicated, well, and Your Honor pointed out, well, was anything that discussed? He says, no evidentiary hearing. Well, you could oppose it. You can have a counter affidavit. There was absolutely nothing that was brought forth to rebut the affidavits in this case. So the judge has absolute discretion to look at that and say, I'm going to relieve you from judgment. Any other?
Nothing for me, thanks.
Okay. Thank you, Your Honor.
Thank you for your argument. Mr. Crusher, you actually have 4 minutes.
Thank you. Your Honor, what it sounds to me like is that appellant or appellee here would like to create a new category of 60B5, a new subcategory, which I will expect will overwhelm the courts because every case is going to have kind of notice problems. The question becomes, who had the responsibility to make sure they got notice? The statutory agent was served by the plaintiff. They appeared, got an extension, answered, litigated. I don't know that discovery happened, but is that the claimant's problem? Is it his responsibility to make sure that the defendant's lawyer does his job?
It doesn't sound like that's the argument. It's either the court or their attorney.
And is it the court's responsibility to make sure the attorney does his job? And isn't that the point of malpractice? I've been in before this court in other cases where you've said, you know, your remedy is to go sue your former attorney. Is that unjust? I would say the vast number of cases in Carrizo-Carresi that we talked about in my reply brief on the first assignment of error, the Supreme Court said it's not unjust not to have an evidentiary hearing on these particular circumstances where it's a B1, it's timely. The trial court said if anybody wants an evidentiary hearing, we'll have one, and nobody wanted one. That's entirely different from here.
So what were you going to produce at this evidentiary hearing?
Your Honor, on April 29th of 2019, which is a month and a week and a half before Mr. No moved to withdraw, the city had issued a litter citation to the property owner, had a hearing, fined the property owner. The materials on that hearing went to this P.O. Box 129 or 159 in Harrison. They appeared. Lisa Kendall, on behalf of CBTM Elberon, appeared at the administrative hearing pursuant to the municipal code. They had the full hearing, so obviously P.O. Box 159 is a good address for them. In the two municipal court cases, 18 CV 4298 and 17 CV 9476, CBTM sued tenants for not paying their rent. They got evictions on these tenants. Clearly, everything went through to that P.O. Box. The statutory agent was working from the P.O. Box. The lawyer thought was working with that P.O. Box. And to blame suddenly in his motion to withdraw, Mr. Noe says that it's been months. It's been I don't have it. I think he said it's been months since he was, here we go, motion to withdraw May 29th. The defendant has failed to communicate with counsel for at least 90 days despite written and oral communications to the client. That's his May 29th, 2019 motion. And yet, they show up at the litter control hearing that was cited in March, and they had the hearing in April. They're not telling the truth about actual notice. They may, my guess is they're not telling their attorneys the truth about lots of things. They can't play, we use P.O. Box 159, but we don't use P.O. Box 159, so you should not hold our neglect against us. Well, it's, Mr. Watering has damages 2 years, he's now 3.5 years, I think, since he since he sued. A year before that, I think he had, I don't recall how long there was between the complaint and judgment there, but so he's 5 years with $122,000 worth of actual damages and permanent disability as a result of the ceiling collapse, and he has no remedy, and the court's just going to give, well, Judge Ruhlman just gave the landlord a pass. That seems to be almost the definition of injustice, explicitly prohibited by the Supreme Court's decisions on 60B. This is a 60B1 case, and they're sliding it into 60B5 because they didn't do it timely, and that's really all this is about.
Well, thank you.
Thank you, Aaron.
Thank you both for your arguments this morning. The case is now submitted, and we'll issue a timely decision.
Thank you.
Thank you. Okay, our final case today is State of Ohio versus Nicole Jones. Mr. Hadamar, would you like to reserve some time for a rebuttal?
Yes, Your Honor, I'd like to reserve 3 minutes.
3 minutes, okay. Whenever you're ready.
May it please the court, I'm Mr. Souter. This case is about a mother doing the best she could under difficult circumstances. The trial court convicted Ms. Jones of child endangering based on evidence showing that she was away from her 10 and 8-year-old children for a few minutes, that both children had cell phones and knew how to use them.
Let me ask you about that. You say a few minutes, how do you know that, or where in the record is that?
The state never put specific evidence of how long Ms. Jones was gone, but the state's only witness is Officer Harrell. So when Officer Harrell arrived, Ms. Jones was not there. Officer Harrell testified that cutting the bolt took 10 to 15 seconds on the door. He testified that moving the couch took 2 to 3 minutes. And then he testified that the children had locked themselves into the master bedroom upon hearing that their apartment was being broken into, that he slid his business card under the door, the children opened the door, that they let him in once he slid the business card under, and then he asked them 3 or 4 questions. Okay. Where's your mother? Did you move the couch yourselves? Why did you move the couch? And that the mother returned to the apartment during that little conversation is what he calls it.
But it was my understanding that somebody apparently, based on the trial testimony, somebody called Children's Protective Services 241 Kids, and there was a 241 Kids or Child Protective Services person at the apartment at the time the officer arrived. So there was some, I don't know whether it's in the record or not, but there was a phone call made, somebody, wherever they went from, drove out to. So it wasn't just a few minutes, I guess is what I think may be more accurate.
Your Honor, in the record, there's only those few minutes because the 241's kid representative, she's there when Officer Harrell gets there.
Right.
The testimony from the 241 kids, or the Officer Harrell's statement about what he heard from her is hearsay. There's a hearsay objection.
Right. But I guess my point is that obviously there was a call. It's in the record. There was a call. Somebody drove out from wherever they came from in Hamilton County and drove to Norwood and then called the police officer when she saw the lock, right?
Your Honor, I don't think it's in the record that there was a call. I think it's in the record that...
Well, something happened. Something brought a 241 Kids representative to that apartment.
Yes, Your Honor. I would assume that's so, but I don't think it's in the record anything except that she was there when he arrived.
Right. Okay.
So we have no idea. A few minutes, 2 hours, 3 hours, 4 hours. Nothing's in the record, basically.
Yes, Your Honor. The only thing in the record is that for the time Officer Harrell was there, or should I say for part of the time he was there, Ms. Jones was not.
Right.
And that she wasn't there when he got there.
Right. How long it took him to get into the apartment
Yes, Your Honor.
and get to the children. Okay.
So the record doesn't show that she was gone for longer than 15 seconds to cut the bolt, 3 minutes to move the couch, and this little conversation with the children in the bedroom.
And the record also does not tell us why she was gone
No,
or what she was doing.
no.
Okay.
No, and that's elaborated on at sentencing, right? Like, there's the explanation as to what she was doing, but that didn't come in the transcript.
Yes, Your Honor. I believe at sentencing there's reference to Section 8, presumably to get a new apartment with a working lock, but again, that's not in the record.
And was the issue about the lock, I'm getting confused on my recollection of the transcript. Did that come up at sentencing or in the trial in terms of the reason why the padlock was there?
No, the reason why the padlock was there only comes in trial to the extent that the lock is broken, the real lock. But that's the only evidence about it, is Officer Harrell sees the lock is broken and that a padlock has been affixed in its place. Which the padlock, under Martin Allen, numerous cases in the First District, leaving children of these ages home alone or somewhere alone for that amount of time or much longer doesn't support child endangering conviction without more. It's not reckless to leave a 10 and 8-year-old home with cell phones that they know how to use.
It seems like the big issue in this case, and this seems to be what the state's arguing, what the judge found, is the fact that the children were locked inside and couldn't get out, and there could possibly be a fire, seemed to really weigh heavily on the judge's decision here.
Yes, Your Honor, but the court says that the risk of a fire is a known risk. We never see the court in its reasoning below say that the risk of a fire is a substantial risk. That seems to be, the padlock seems to be the only difference between this case and others where children of similar or younger ages were left alone.
Is there anything specific that the court points to as constituting the substantial risk?
Strangers. The court says the children make the case. Their fear when their apartment was getting broken into suggests they were afraid of strangers.
Well, yeah, I mean, someone's breaking down their door, like, I would be afraid about that. Who wouldn't?
Yes.
I mean, it just happened to be police officers, fortunately for them, but.
Yes, Your Honor, and as we see, the children are, the children have moved a couch in the way of the door by the time it's being broken into. They've then gone into the master bedroom and locked themselves in. They come out when Officer Harrell presents his card. So it does appear that the children not only had phones and knew how to use them, as Officer Harrell testified, but that the mother, or that the children were children who knew to be afraid of strangers and knew not to be afraid of police officers.
And the officer testified that they were happy and healthy. What did he say was the basis for thinking that they had some irrational fear or maybe irrational fear of strangers?
He didn't, or the trial court didn't permit him to speculate about why they were afraid, but he said they were happy, healthy, and good spirits after he arrived and identified himself, and they had a nice little conversation. And then, Your Honor, he also said that there were no readily apparent risks within the apartment.
Well, there was mention, you can address this, of some bullets and some marijuana residue, right?
Yes, there was. It doesn't appear that the trial court weighed that heavily in the decision. And additionally, I would say, as Officer Harrell testified, live ammunition without an unsecured firearm, which there's no record of, you can't do much with it, is what he said.
And what was it with the, was it just marijuana residue?
Marijuana residue, or he testified specifically marijuana residue in cigarettes in an ashtray.
Okay.
We don't know more than that. But I would say that on these facts, leaving children 10 and 8 for, in the record at least, a few minutes in an apartment would mean that no parent could ever leave a child at home. If there's beer in the fridge, if there's a liquor cabinet that's not, secured beyond childproof, if there's chemicals under the sink, marijuana residue doesn't pose any more significant danger than many things in a home. Moreover, if the trial court did find that strangers was the risk, as fire is too speculative, the trial court shouldn't have had the evidence before it to find recklessness, because Ms. Jones clearly mitigated the risk against strangers. The daughters were both equipped with cell phones. They knew how to use them, and as we've covered, they apparently took precautions when they felt that their home was being broken into by strangers. Additionally, there's no evidence that she was gone for more than a few minutes. As far as fire, to the extent the court, that was the court's reasoning, fire here is too speculative to support this conviction. There's no evidence of open flames. This is June 29th of last year. It's in the summer. And there was no evidence, as Officer Harrell testified, of dangers of any kind.
Was there any evidence of other ways to get out of the apartment if there was to be a fire?
The apartment is on the second floor. Mm-hmm. That's all we know as far as exits or entries.
We can presume there's windows?
We could presume there's windows,
we don't know
or
if
it
they
couldn't be called a
open.
two-bedroom apartment. Oh, sorry, Your Honor.
We don't know if they open.
No.
Okay.
So I would say that the padlock, it has to be on the outside, right, if you're using a padlock to lock your apartment, because otherwise you can't lock it when you leave. This is maybe imprudent to lock your apartment with a padlock instead of a real lock. It's an apartment.
The real lock was broken?
Correct.
Okay.
It's like using a spare tire on your car. You don't want to drive too fast with the spare tire. If something happens that's unexpected, like at an intersection, you need to accelerate or brake.
Well, the padlock's really, as I think about it, not any different than just a regular deadbolt without a switch if the kids don't have the key, right? Like, it's the same thing.
Correct. It's the same. It's the same as a child left home who's too young to know how to open the door. And it may be we don't know why Miss Jones locked it that way, except that the lock is broken. But it may be that she determined in her head that the risk of strangers or even the risk of a child wandering away was greater than the risk of fire with no evidence of anything that might spontaneously cause a fire. One appellate court did find that fire could be substantial risk, which is a strong possibility as contrasted with the significant possibility of danger. And that's State versus Marzetti. But there was an oven with the door broken off being used to heat the home. And there were combustible materials left on top of the oven where they might fall into the fire. Here we have nothing. It's an apartment. Some apartment buildings catch on fire. I don't think there's a strong possibility of any particular apartment building catching on fire without more. I would add to that, like you said, that, Your Honor, that children were confined, which is no different than many ways that children are confined, like a crib, like a door that they don't know how to open. Or we also, the First District case, State versus Massey, which is a little different. A 2.5-year-old there was left in a bathtub confined for 4 minutes without supervision, which the record doesn't show much more time than that here, except here the children 10 and 8 were left in a safe apartment rather than a bathtub. And that court found that that wasn't enough to create a substantial risk, that any risk from being in a bathtub for that long, even at 2.5, was speculative.
I presume the bathtub was full of water in that case?
Yes.
Okay. You are at your time if you want to reserve 3 minutes.
Yes, Your Honor, I would, if there's no further questions.
Great, thank you.
Good morning, Your Honors. May it please the court, counsel. I don't have a lot to add to what's in my brief. Just some of the factual questions that the court had. During sentencing, she indicated that she put the padlock on the door because it was a rough neighborhood and she was afraid that something would happen to the kids. And as Judge Winkler pointed out, that the amount of time that she was gone was at least enough for 241 kids to be notified, and for 241 kids to notify the police, who then took them some time to respond. So that's about.
Have any idea how long?
That's the extent of whatever clue we have as to how much time it was, however long it would take to make 2 phone calls.
Well, I guess part of my question is the time a key to the state's position here? Like, would it matter whether it was 2 minutes or 3 hours?
No, Your Honor, I think what this, the facts are undisputed in this case. I think that this court just has to make the determination, as the trial court did, whether padlocking these children in a room was qualitatively different from just leaving them alone, and whatever risk that would be inherent in.
Well, I think that's part of the question. Like, parents leave kids alone all the time, and I guess I worry that if we were to kind of endorse what you're saying, that like suddenly half the parents in this county could be susceptible to child endangerment.
Understood, Your Honor. I would note that there was the aggravating circumstances in this case, as this was the only exit from the apartment, and it did indicate that they were on the second floor. So if something did happen, and I know the standard of substantial risk, if something did happen that would place these children in greater danger.
It seems like it would be even more danger to leave the padlock off the door since the lock was broken.
Understood, Your Honor.
I feel like the mother was in a bad spot here.
I agree, and I think that's
Which sounds like exactly why she's trying to get out of that apartment.
Yeah, exactly. And that's part of the weighing factor that the trial court engaged in this case. And this court either agrees with that weighing or it doesn't, and I have nothing to add to what's in the record. Unless there are any questions, I'll rest on my brief.
Thank you.
Thank you.
You have 3 minutes left.
Thank you, Your Honor. I would reaffirm that we don't know why the mother left, but we do know that she was mitigating and balancing risks. She locked the apartment rather than leaving it unlocked. She equipped the kids with cell phones, and apparently these were 2 children who knew the danger of strangers, or at least the danger of someone actively breaking into the apartment. We really don't know, and it's not in the record, how much time elapsed. Could have been a few minutes between when Officer Harrell arrived and whenever the notification happened, but it's just not in the record. The state could have called the 241 Kids representative if they wanted to prove that.
I guess the state now says it doesn't really matter on the time.
So now the state's only talking about padlocking. If this case weren't to be reversed, it would suggest that no child can be confined for any amount of time, even a short amount of time, in safe circumstances otherwise, because if there's an emergency, it would delay the amount of time getting out. I would add that here the lock was cut in 10 to 15 seconds, and Ms. Jones was apparently a few minutes away or gone for just a few minutes. So if there's an emergency, the risk she's created, if any, is that they don't get out quite as quickly.
Did one of the children call her? Was that in the record?
There's no record of that. The only evidence is that they had phones and that they knew how to use them.
Right. Okay.
And that she returned while they were talking to the officer in the bedroom quickly after he got there.
Okay.
If there's no further questions, we respectfully ask this court reverse and discharge from further prosecution, or if you believe it's the credibility of the evidence test, remand for new trial. Thank you.
All right, thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Have a good rest of your morning.